Mississippi. No, I spent a lot of time in Mississippi. I was head of litigation at International Paper. Districts.
Testing, testing. Testing, 1, 2, testing. Testing, testing, 1, 2, testing. Testing, 1, 2. Hello, everybody. Sorry. Hello, everybody. On behalf of Cornell University, it is my pleasure to welcome and thank you for coming this evening. Hello, everybody. Hello. We're going to quiet down. I think we're ready to start this evening. So, as I was saying, on behalf of Cornell University, it is my pleasure to welcome and thank you for coming this evening to this very special event. My name is John Zelenka, class of 2003, MBA 2012, and I am a staff member in Alumni Affairs and Development based here in New York City. I run staff-driven alumni programming throughout the Northeast Corridor, from Metro New York out to DC, Philly, and Boston, around timely topics of interest with the goal of bringing Cornellians together. Additionally, I'm happy to say I'm joined today by several other colleagues located from both Ithaca and New York City. We each have a red staff ribbon on our name tags, so for the remainder of the event and after, we're all available to answer questions about Cornell's presence here in the area, or how you can get involved, support Cornell, or learn more about Cornell initiatives. I'd also like to take a moment to welcome Cornellians from around the country joining us tonight. We are currently live streaming this program and are being watched from coast to coast as we speak. Last I checked, we were a little over 150 Cornellians checking in. So
Over 200.
we're now over 200, so welcome the Cornellians from around the country. In terms of an update from Cornell, there are a lot of exciting things happening. Over the next 4 years, as we march towards our sesquicentennial in 2015, Cornell has established 4 strategic goals. We will recruit the best faculty for the future. We will enhance access for the most deserving and diverse students. We will bolster public engagement anchored in Cornell's academic strengths. And we will strengthen our people, programs, and facilities to support and promote academic excellence. All of this has and will be supported with the continued extraordinary and generous support of alumni, parents, and friends as we approach our goal of raising $4.7 billion by 2015. Another exciting aspect is our progress with the Cornell New York City Tech Campus. In December 2012, as many of you may know, we announced that Cornell had won the bid to secure a one-of-a-kind graduate campus here in New York City on Roosevelt Island focused on applied sciences. The vision is in that in 20 to 30 years, this will be a 2.1 million square feet of state-of-the-art academic and residential space, holding over 300 faculty and 2,500 graduates. This is a transformative vision that will impact Cornellians well into our next 150 years. While the campus is being built, Google announced a 5-year partnership with Cornell and gave us 20,000 square feet of teaching space here in their building on 17th and 8th until the campus is complete. As of this most recent January 2013, our first group of 8 students began taking classes and are shaping the future of the Cornell NYC Tech program, curriculum, and opportunities as we speak. Most recently, Mayor Bloomberg announced an amazing $133 million gift to the Technion Cornell Innovation Institute, funded by the CEO Emeritus of Qualcomm, Irwin Jacobs, class of 54, and his wife, Joan Jacobs, class of 54. What feels like almost every day, there are new and exciting announcements regarding this initiative. For more detailed information, please visit now.cornell.edu/NYC Tech, TECH. Finally, in terms of tonight's program, who would have guessed almost a year ago when we were first discussing this idea that privacy and personal data would be so front and center in every news outlet around the world the last few weeks? From the breaking news about the NSA tracking phone records to prevent terrorism, to debates about the increased use of personal data, both internally and externally of companies of all sizes for a variety of goals, reasons, and purposes, to large conglomerates being multinational and spread across the world while dealing with cybersecurity threats changing and advancing every day, to emerging and transformative technologies like Google Glass, increasingly smartphones, computers, and tablets, and a constantly online culture. Privacy and data is on everybody's mind with all of this going on. Is there even such a thing as privacy in this technological world anymore? There are benefits, there are trade-offs, there are positives, there are negatives, there are companies addressing this debate proactively, and there are others that have their heads in the sand. Some people think we're getting closer to the society described in the classic book 1984, with Big Brother watching over us all the time, and there are others leading the charge and moving forward with these advances. No matter where you fall in the debate, this is a fascinating and timely topic that impacts everything we do. With that in mind, we are very excited to have pulled together 6 industry experts to discuss and debate these very issues. Tonight, you will hear from them on the role of personal information and protecting data, balancing user privacy with law enforcement, implementing responsible data stewardship and governance, and their thoughts on current events and what they see on the horizon. We are grateful to Hunt & Williams LLP to be hosting this exciting program for us tonight in their fabulous space here in the MetLife building on the 52nd floor overlooking Manhattan. The 6 experts with us tonight are Tracy Matrano, JD, class of 95, who's the Director of IT Policy at Institute for Computer Policy and Law at Cornell University. We have Stephen Wicker, the Professor of Electrical and Computer Engineering at Cornell University. We have Keith Enright, a Senior Privacy Counsel at Google. We have Mark Fasciano, class of 90, who's the Managing Director and Internet Entrepreneur at Canrock Ventures. We have Lisa Soto, class of 84, who's the Head of Privacy and Data Security Practice here at Hunt & Williams. And we have Joanne Stonier, the Senior Vice President and Global Privacy and Data Usage Officer at MasterCard Worldwide. To save some time on the introductions, each of you have their complete bios on your chairs. This evening will be split into 3 parts. First, Tracy will set the stage for the evening and give her own insights on this timely topic. Then she and Steve will have a conversation with one another, giving their keynote address about the changing landscape of lawful access. They will touch upon what is in the news recently and where we are going. They will speak for about 20 minutes, and then we'll take about 10 minutes of Q&A. After they are done, we will have a very, very short break of about 5 minutes while we reconfigure for the actual panel discussion. The panel, moderated by Tracy, and including Keith, Mark, Lisa, and Joanne, will then discuss a variety of hot topics in global privacy and data security. They will talk for about 40 minutes, and then we'll have another 20 minutes for more Q&A from the audience. In terms of Q&A, we will be taking questions from those here in the audience live and those online. So for those on the live stream, there is a chat window that you can post your questions. My colleague, Ashley, will take a few and will represent you guys to the panelists. If all goes smoothly, this will bring us to about 8:30, and this will mark the conclusion of the program for the evening. As you can imagine, we can spend all night on a variety of aspects around this topic. Each of these experts will only be able to scratch the surface tonight, but I'm sure each will give you plenty to consider as you listen and react to their discussion points. Now, without further ado, I would like to quickly introduce our moderator for the entire evening, Tracy Matrano. Besides her professional role at Cornell, Tracy is currently on the boards of the National Institute for Technology and Liberal Education, Teach Privacy, the Cornell Daily Sun, the Tompkins County Broadband Committee, and Tompkins County Public Library. She's a frequent speaker at conferences, colleges, and universities on the subjects of internet, national and institutional policy, electronic surveillance, and government regulation, copyright, and social networking and privacy. She has a doctorate in American Women's Health from Binghamton University and a law degree from Cornell Law School. She has a teaching appointment in the Department of Computing Information Science at Cornell, where she teaches a course called Culture, Law, and Politics of the Internet, and also writes a blog for higher education entitled Law, Policy, and IT. Tracy, the floor is all yours.
Thank you, John, so much, and thank all of you for coming this evening. It's a fabulous showing on such a great evening. But the issues that we're here to discuss are critical to us and could not be made more so with the evidence of what's going on in the last week or so in the international media, as John mentioned. I looked over the places from which you're all coming this evening, who you are, where you work. We have many lawyers here, risk managers, privacy specialists, technical security specialists, and many people, who are here because these issues are of genuine interest to everybody. And so we thank you for coming to speak with us tonight and share your views as well as to hear some of the views that we all have to share. And when the panel comes up, you'll have a chance to meet all of them as well. I've been asked to give a general framing of our issues this evening, and so with the specialties that you all have and the expertise and the work that you've done, you may find this really very pedestrian. But bear with me, I just want to lay a little foundation so that we have something upon which to work as we build some of the topics that we'll be discussing. First of all, privacy is a very complex and difficult concept. So long as we understand those difficulties, I think we can keep our discussion in that broad framework while also talking about specific issues. The factors that I would like for us to keep in mind tonight, and John has already mentioned them, are certainly the law. And again, with recent events, this is very pertinent for us to address. The technology that has changed expectations about privacy. It began some of the first American law regarding privacy back at the turn of the last century, and it continues to be a driving force in cultural expectations about what privacy is and how it should operate in our personal lives, in our professional lives, and in the use of information generated about us. Market, of course, is a part and parcel of how technology comes into our hands, how we are using it, and how the market wants to use information about us. Those will be topics that we will discuss not only in the keynote that Steve and I will give, but during the panel discussion. And then, of course, cultural and social norms. And I think that's where we really think of privacy. My cousin wrote me today when I mentioned I was doing this, and she made a paraphrase of McNeely's famous remark about, well, don't you know privacy is dead? And I wrote back and I said, well, when I try to grab my 16-year-old son's iPhone, I did not think that privacy was dead. He certainly had an interest in holding on to that phone. So the cultural and social norms that surround us are probably the most poignant aspects of privacy, but they get spelled out in how our technology operates, what our law has to say about it, and how the market wants to use it for its own benefits and purposes. Again, just laying a level, I would like to suggest that there are 5 big areas in American law that address privacy, and it might be helpful for me simply to mention them so that we have some sense of the categorization in mind, because when we start asking questions, we will want to know, are we talking about electronic surveillance? Are we talking about corporate privacy? Are we talking about personal privacy? So let me just lay these out, and from there I'm going to skip right over and start chatting along with you, Steve. So the first kind of privacy is the one that I think we think about first when we hear the term, and it represents the area of constitutional law that addresses family planning and sexual freedom. That is probably the least of the 5 areas that we will be addressing at all this evening. However, I think it's important to mention it because it's within this larger context of what privacy represents in our lives and why it's important. The second area is one that has been in the news, especially in the last fortnight, and that is electronic surveillance, and more in particular, the rules and laws stemming mainly from the Fourth Amendment about how and in what ways the government can appropriately monitor telephone conversations, monitor content of internet conversations, or get what's called conversational detail, or now I think the press is favoring the term metadata, that is calls that you've given, and what level of law enforcement documentation is necessary, what degrees of evidence are necessary. It's part of a whole area of study in law that one thinks of with criminal procedure. The Fourth Amendment is a huge area in that aspect. So when we hear that term, electronic surveillance, we think of the National Security Administration. We most prominently would think of the Electronic Communications Privacy Act, which was established in 1986. Now, how many of you had computers in 1986? And how many of you were on the internet in 1986? And how many network systems existed within our corporations for trading data and so forth. Now, there were some people who raised their hand appropriately because in the work that you've done in science, engineering, computers, and technology, indeed they did exist then. But I mention that to suggest that this is a law very much on the minds of the Senate today. It is under revision, and it's critical that it be revised because it was a law revision itself of an earlier law in the 1960s, the 1968 law, that began the jurisprudence around wiretapping. And so after winding it back to the 1960s, when it was first established that law enforcement needed that kind of protection, we are here today with the questions about, is the FISA or Foreign Intelligence Surveillance Court an appropriate way to conduct surveillance of terrorism? Is the Electronic Communications Privacy Act the appropriate way to handle what are called the Title III courts or criminal investigations using evidence of electronic communications? And so that in and of itself is one whole area of law around the question of privacy. The third area, you may be familiar with, many of you, because of the work that you do. And this would be the public laws in our society that define sectorally certain kinds or classifications of data that the law protects. Now, in higher education, we are most cognizant of the need to protect education records. And all of your records when you were alums were protected, and indeed, they will continue to be protected until you die. Then the protection ends. So make any needs that you have to protect those records. So you might want to start working on that now. Yes, exactly. Plan ahead. But there are other laws with which we've become increasingly familiar over the last few years. The Financial Modernization Service Act, some people call it the Grandlee-Flyley Act, that protects banking information upon which interest is garnered. For a place like Cornell, that's just the bursar's record. But for many of you in corporate America, and especially in banking, that means that you've got a wide set of records over which you need to maintain a certain regulatory oversight. And the other one that everyone knows about, because you've had to sign it when you go to visit your physician, is the Health Insurance Portability Accountability Act. Although, keep in mind that that law only applies for those covered entities. There are state laws, however, that may protect specific pieces of information about you, for example, an HIV status. So those are the big state federal laws that we have. There are some state laws, as I mentioned, that are sectoral. They just protect certain levels. And when the panel comes up especially, I'm pretty sure they're going to want to indicate that the United States is in an interesting tension with other developed countries in the world, the European Union, Japan, Australia, that have a more comprehensive view of data protection. And I'm going to rely on them to do a deeper dive into a description of what that means, how global corporations operate in that circumference, and help us appreciate where the United States is on that question, and maybe give us a little bit of an answer why. So what happens if you make a mistake in this area? Usually it's financial damages that would be the consequence there. The fourth area of privacy law are what we call torts. Now, I had to go to law school in my 30s before I knew that that was not something you made with marzipan and a little bit of flour or chocolate. But torts would be civil actions of an individual against another individual. If my friend Emily Posner, who is here this evening, for example, were to have intruded upon my seclusion, or if someone were to disclose facts that really should be private about me on a social networking site, I could bring a case against Emily, or I could bring a case against the person who disclosed those kinds of facts. And that would be one individual against another. It's an emerging area of law, even though it began at the turn of the last century. Emerging because of the internet. The scope and amplification that the internet offers about information has caused this once relatively marginalized only mostly for famous people, to be brought into a tighter focus for everybody, because we can all be famous forever on the internet. And that is an interesting growth area, I think, for many attorneys. Maybe we'll have some people discuss that. Lisa might want to talk about that a little bit more. The last area is administrative law, and again, as John said, we could talk about all of these things all night. I only want to mention it here because when you hear about the FTC looking into Google, and of course we've got Keith here this evening, and maybe he may want to mention something about any of these issues. But when you hear about that, or when you hear about the FTC creating a rule that there has to be a privacy policy on every website that is used for a financial transaction, if you hear about Facebook coming to an agreement with the government regarding notice to users when they push out information, those kinds of agreements are done through administrative law. And right now, I would say the Federal Trade Commission, the FTC, has been the agency that has been doing the most in this area. There might be some aspects of privacy when it comes to net neutrality, for which the Federal Communications Commission might also be involved. But really, when it involves privacy, even something like the enforcement of the Child Online Privacy Protection Act. So that's a piece of legislation that would be a public legislation, but the enforcement of it might be handed over to the Federal Trade Commission. So those are these 5 areas of law that I thought it would be useful for us to be able to distinguish when we have the conversation. But now I would like to just ask Steve a few questions, beginning with, what do you make of the news the last week or so?
Well, as you know, it's been a lot of fun. In fact, we were at the same Privacy Law Scholars Conference when all this came out. For those of us in surveillance studies, I can simply say that our government is the gift that keeps giving. It's been really exciting. We would wake up one morning and say, okay, what happened today? What's the new revelation? It's been very interesting. And of course, surrounded by lawyers and some technologists, there was a lot of detailed discussion. You know, has the Stored Communications Act been violated, or does the Pen Register Act apply? We can get into that. In fact, I'd be happy to get into the technical side of that. But I'd like to stress that some good things have come out of these revelations. First and foremost, I'd like to talk about the cellular revelations, the scooping up of what is called metadata by the NSA. And by the way, this is metadata for everyone in the United States who has a cell phone, not simply those who are calling foreign countries or something like that. It's everybody. It's all of us. And so I think what is good that will come out of this is that people will come to realize that cellular is a surveillance technology. It's always been a surveillance technology. But it's becoming much more of a surveillance technology as we do more and more on our cell phones. Glorious old days where the phones weighed what seemed like 20 pounds and all you could do was talk on them, they tracked you, but not very well. Today, think of all the things you do on your smartphone if you have one. From email to texting, all of this is being gathered up. And the location privacy in particular is a huge concern because the resolution of the location capability of our handsets is becoming finer and finer literally every day. So the second thing that I think is good that will come out of this is our understanding that the distinction that's embedded in the laws Tracy was talking about, the distinction between content, the actual communication of the phone, and the context, or what is being called metadata, is vanishing. Our law is based, of course, on the Miller case, goes way back, the third-party doctrine. It's embedded in Smith versus Maryland, where we talk about the fact that the numbers you dial, you have no reasonable expectation of privacy. Well, it's no longer the numbers you dial, it's everywhere you go all day long. And I think we've come a long way in terms of our technology, and you're exactly right. We need to revisit these laws because they are archaic. The internet became public in 1995, 9 years after the ECPA was promulgated. Time to update.
Mm-hmm. Oh, that's terrific. Do you have any general comments also about privacy that you want to offer with respect to the relationship of law and technology from the technologist's perspective?
Well, from the technologist's perspective, we like to design things. We like to make things or repair old things that seem broken. There's a lot of very interesting research to be done, and that we're engaged in at Cornell, and looking at existing information networks like the internet, like cellular technology, and asking ourselves, how can we fix this? How can we make it less of a surveillance technology? And that's been a lot of fun. It's been very interesting. But there's a second piece as well. We've got people who are dreaming up new networks, new technologies that are going to be completely different. And so the question arises, if you're designing a new information technology, how do you make it privacy aware? And so we've developed some rules, some guidelines, I should say. Mm-hmm. No rules in the design. We've developed guidelines such that if you're considering privacy from the outset, it's much more likely that the result will be a technology that's less of a danger to our children and ourselves from a privacy perspective. So privacy-aware design is what we call it, and hopefully it'll catch on. I think it touches on so many things that engineers do, but also technology ethicists, so many other areas that are important.
Well, I'm interested in your probing that a little bit more, Steve, because I noticed that you called these technologies such as cellular surveillance technologies.
Yes.
I'm curious about that.
Okay, well, it sounds dramatic, but as we've seen in the last 2 weeks, it happens to be true as well. These technologies, let's think about what we do with our cell phones. Very few of us lend our cell phones to someone else. So when that device, that handset is being tracked, say within a few meters, all day long, at least while it's turned on, it's tracking you. So it is, in essence, a surveillance technology. That's part of how it was designed. It does what it does really well. But I think we've shown it didn't have to be that way. And I'd just like to note, there's a strong educational element in this too. Our kids love to use apps. My older kids think they're great. My youngest wants to play with my phone all the time. And of course, at the university level, it becomes an issue because we've got a lot of young students, enjoying the world and their freedom for the first time, and they're using these technologies, and they're creating a lot of data, and they don't know where it's going. So I'll hand that one to you because I think you know a lot more about it than I do.
Well, Steve, we can agree that the law is in tension right now with the technology. So if you have a technology such as cellular, it certainly could be used for surveillance. And with laws that are as antiquated as many of the federal laws are, the Electronic Communications Privacy Act in particular, at Cornell and other institutions around the country, we have put policies into place to make clear what the rules of the road are for our institution. So that if the law is difficult to comprehend and if it's difficult to be sure that we're following all of its particular permutations without really even knowing what those permutations are, having a policy that certainly is above the law, it doesn't go below it, but is above the law, I think helps everyone in the community. It retains the missions for the institution by maintaining freedom of speech and open inquiry. It assures students that notwithstanding their fears, we are not sitting up all night reading their emails as we're often alleged to be doing.
Unless they send them to us, then we have to.
That's true. And it also helps administrators in order to be sure that they're doing the right thing by way of being employees in their organization, be it Cornell University or any other college or institution. And one of our speakers tonight, I think, is going to talk a little bit more about how technology and employee issues intersect. So we've relied a great deal on policy. We have often said in the area of law and policy of higher education, just throw the law out and go ahead and make sure you set a good policy. Check it with your institutional attorneys to be sure that you're at least hitting that threshold standard. And then help people understand for what institutional purposes you've established the policy, help them understand how to comply with it, and then make sure you do a lot of education, because as you educate about policy, then you are necessarily educating about the law and the technology, user interface and social norms. And then sometimes you can even get to questions of the market. For example, when higher education was hit with some of the gossip sites that were affecting students very deleteriously, we often had to educate about how it was that these sites existed as a business model for the people who established them at the expense of the students who found themselves defamed or slandered or very upset, to say the least, about some of the comments that were made about them online. And so the best way that we were able to help parents as well as students was to help them understand something about the internet in general and something about the business models of those sites in particular. So we find that we really touch all the areas when we do the education, the law and the policy, the social norms, the usability, how the technology functions, and then also how the market shapes so much of the behavior of all of these other aspects as well. Tell us more then about your research. Give us an example of what privacy awareness design is.
Okay, well, one example is, well, as I've already mentioned several times, your cell phones generate location data. That location is tied to your account, so it's essentially tied to you. This data is kept, at least by some service providers, indefinitely. So we asked ourselves, as technologists, how would we design a cellular network that didn't track the individual, that somehow used random certificates instead of your phone number to route calls to your phone? So you'd still have the same capabilities, you'd have the same service, but the service provider would not know who you were. And it turned out there were some really interesting computer science problems to solve, something called zero knowledge proofs, which always sounds great. In education, talking about zero knowledge it's always fun. And we were able to come up with some solutions. So, and it was a nice big project. It had a lot of students involved. But I'm very happy to see one of my PhD students, former PhD students here tonight, he graduated successfully. And it's been an area in which we can get a lot of interesting things done technically by involving lots of students, and by that I mean undergraduates as well as doctoral and master's students. And so they're doing something interesting. They're learning about the technology, but at the same time they're learning about privacy. They're learning about the importance of privacy. They're learning that, you mentioned this before, the business model does not favor the individual. The business model takes the data and does everything it possibly can with it to make money. That's all right, as long as it's understood by everybody involved, not just the business. So these projects offer tremendous possibilities for the students, and we're getting corporations involved as well.
That's great. And what role do you think higher education should play in this national conversation, if it's a global conversation?
Well, I think we actually have a lot to help with. How shall I put this? There are people who know a lot about cellular, but because of their positions, they can't be as frank as, say, some random professor from Cornell University. So when we look at questions like, what is the difference between content and context data? Is there a way that we can actually develop metrics to show how much is revealed by context data? Turns out the answer is yes. And so using information theoretic techniques and other approaches, we can show that, you know, that supposed metadata that you shouldn't worry about may actually say more about you, your beliefs, your preferences, and your behavior than the content of your calls. In fact, I think about how I use my cell phone on a typical daily basis. The content of my conversation is not very interesting, but you know, everywhere I'm going, that will say a lot about me. You know? So I think that's important. There are lots of other technical issues where we can weigh in and talk about how the conversation might be headed in the wrong direction. You know, we need to look at these laws and think about how old they are, how they do not capture, for example, email. We talked about this the other day. Stored Communications Act treats email in a very strange way. And that's something that technologists, academics can speak to freely. Thank goodness for Tink.
Well, I agree with you. I think higher education does have an important role to play with society at large and even globally to help shape this conversation, to be informed, not constrained by market interests, and to search for knowledge and truth, if I might even bring up those words. In that interest, then, I'd like to open it up, unless you have some other initial comments, to the audience and see what kind of questions they have.
I'm looking forward to the questions.
Fantastic.
So just as a reminder, we're going to take 1 or 2 questions here. We have about 10 minutes to have this conversation, then we'll do a quick short break and then go into the panel conversation. So.
Great, John. Thank you. Yes, sir.
Is there an implied consent when people use technology that they're willing to give up privacy? And does that have a legal status?
So the question is there applied consent that people, implied consent that people give with respect to their privacy
Or
when they use
giving
technology?
up their privacy?
Yeah, giving up their privacy when they use technology. What do you think?
I think I would go back to the third-party doctrine, the idea that you're somehow giving up information that you provide to a network company, for example, a service provider. You should know, according to Miller, Smith, and some of these other cases, that you're giving up something so that your call can be processed. And it's that knowledge on which that implied consent is based, I think. Speaking as one who barely knows enough law to be dangerous, I would say that that implied consent is on tenuous ground when the user doesn't know how the technology works, when they don't know what's being collected. And so I'd start to question them. And when the form that is checked off is 65 pages long, no one reads it, I would question the extent to which consent is really there.
Yeah, I think I have to agree with your leaning there, Steve. The United States, I think, lacks a concept of policy overall. We don't address these issues as policy questions. And this area is one good example, where if we did, we might, from the beginning, think, gee, we really need to consider where our laws are in this question, where our culture and tradition is at this time, how and in what ways the technology functions and operates or could change with privacy awareness design, and how people might find that they're using it, and proactively begin to think about all the complexity of these things instead of always just saying it's the technology that's doing it or allowing the technology to do it. So I would advocate for a more proactive approach to thinking about these issues as a general public policy matter from the beginning. Thank you. Another question? Yes, ma'am?
If I understood correctly, what you were saying in terms of discussing the information that is available about where we are and all that, right, use of our, just holding our own cell phone.
Yes.
If I understood correctly, it sounded as if what you were saying was that that was disturbing and concerning, and that there are technically ways to separate your phone or your instrument from that information. And if
Yes.
that's the case, why isn't there a groundswell of us in this country that is saying that has to happen, we want that, and why don't you ever hear about that, and what can we do about it?
I'm going to shape the question to be sure everyone heard it.
Yes, the question was, given that there's technology, let me back up a step, given that this location information is such a privacy concern, and given that there's technology available that would make it less of a problem, that would change the cellular system to separate our location data from our actual accounts, knowledge of ourselves, why isn't there a groundswell? I have to do this, forgive me, but my book comes out next month. I've never met this young lady before.
But the check is still in the mail.
No, let me give you a serious answer, I'm sorry. It's complicated. I mean, few people could stand up and explain, come up to someone on the street and say, tell me how your cell phone works. How does that call get routed to you? It's actually kind of complicated. I have been teaching it to freshmen successfully, but it's something that takes a little bit of time and a little bit of education. And the awareness of the problem, the national level awareness that this location data says a lot about you and it's readily available, I think we're only a few weeks into that. The technology, our projects in particular are only a year old. So, hopefully we will see a groundswell. The poll data, though, is ambiguous. As you probably know, the polls taken after the revelation that the NSA was basically scooping up all this data said, well, people sort of expected it.
Are there any statistics on how people would feel about that if it weren't tied to terrorism? In other words, in some ways, going back to the initial question that we had about how to shape all of this implied consent or not, if it weren't tied to national security.
I think it'd be really hard to tease that out. You'd have to somehow get a community of people to speak with who weren't aware of the potential for terrorism, and I think that would be virtually impossible. But having said that, there's definitely been a tendency in our country to ratchet up the level of surveillance when something bad happens, and then it doesn't go away. Those sunset clauses, the sun never sets.
It's true. We have reinvigorated the Patriot Act many times from its sunset clauses. We have a question from the internet, and then I will come to the other hands that I've seen here. This gentleman will be next, and then I'll move to this side of the room. Please.
Sure, there are actually two questions that came in, but one I believe was just answered. So I will go with the one from Los Angeles.
Okay.
Tonight's speakers, oops, that was mine. Sorry, this is small. How do you feel about privacy of government workers when using government-provided cell phones versus personal cell phones to conduct government business, maybe via a stipend?
Well, we have a very interesting case on this, the Kwan case that was decided a couple of years ago or 18 months ago. And I would say that the summation of what works for that case was that there was a policy that made it clear that so long as you were using the government-issued phone, that and it was a police department, had the right to inspect any of the data on it. Whether or not the individual whose data was investigated and found to be violative of other policies of the police department recognized that policy, had read the policy, knew about it, I don't know. But because there was a clear policy, then that really was the determining factor in that case. I'm simplifying, but how do I feel about it? I think it's important to have a policy to let people know what the rules are. And if the government wants to have a policy saying that the data on the devices is available for inspection, that seems perfectly fair to me. And then people can go ahead and take the opportunity to purchase their own personal phones, which would then fall under the Fourth Amendment protection and not be under the employment rules that the government would set as an employer.
I must admit, I had mixed feelings with regard to that case because of something that I like to call the Facebook effect.
Mm-hmm.
You know, you think you're just talking to your friend,
Mm-hmm.
unless you're reminded continuously that, you know, what you're dealing with is basically putting stuff up, you know, on a billboard in Times Square or whatever your favorite equivalent is.
Right.
You're going to forget. You know, when I text my children, my wife, it never occurs to me. I don't think about the fact that this is freely available, you know, to the service provider. And, you know, in some ways, that's what makes it such a good technology.
Mm.
You know, I can enjoy that private conversation. On the other hand, when it comes to if my cell phone had been provided by Cornell, or in this case, the police department, I think a continual reminder is important.
Mm-hmm.
Not just a policy that you file away and look up when you feel like it, but a privacy policy that is, say, monthly, reintroduced to the workforce. So that, yeah, they're reminded, by the way, you know, if you send out text messages on your police-provided phone, we might actually look at it.
Mm-hmm.
So I think that would be a good approach.
Mm-hmm.
But it's hard for me to argue against the results of the case.
Right. This gentleman.
We all have the choice of turning off the cell phones or not even using it. So really, isn't this a whole issue that can be solved by the free market? If someone is saying, I'm paying $50 a month for my phone, and everybody in the world knows about the data that you're doing, but for $400 a month, I'll create a legal structure that anonymizes the data and maybe host it in a different jurisdiction outside of the reach of the United States. But it's going to cost you $300 a month. Or you can not spend anything, zero, and you have great privacy.
Well, that's a great question, trying to put together the questions of how the market can answer some of the concerns that people have and then what role the government would or wouldn't play in all of that. I guess my first thought is, I still always do think of myself as a citizen first and a consumer second. And I would like American corporations or corporations that work in the United States to be aware of the culture and traditions that do shape that concept of citizenship. If we do find the technology combined with the profit motive leads us in directions that's compromising that value, then I think that is the time when people can stand up and say, hey, wait a minute, this is going a little bit too far. And then adjust these factors of the law and the market in such a way that we can still feel as if we're having the essential freedoms for which we're very proud to have in the United States. Steve?
I think you raise a really interesting question, and it's one that we've actually been exploring. One of the wonderful things about Cornell is it is so interdisciplinary. So we have a behavioral economist, a moral psychologist, technologist, myself, and a number of students working together to try and answer exactly that question. How much would people be willing to pay for a cell phone that did not keep their data? And the running joke is $17 extra. But you know, numbers like that, they give a false sense of precision. There really isn't a fixed number, but it is clear people are willing to pay something. You know, and part of finding out how much they're willing to pay involves education. You know, this is what you've got going on now. How much would you like to pay to have something that works a little differently? And I think it's a really interesting question, and it turns out there is a real market for privacy.
Oh, absolutely.
Simple example, you've got apps Perhaps you have apps on your cell phone. You have a choice. You can use the free one and get all the advertising. Or you can use the one that costs $5 and there's no advertising. And the data collection rules are different. So very interesting. I'd like to see that market develop.
Yeah.
I think we have time for one more.
One more, very good. Someone had their hand up here, this gentleman.
I think there's a basic issue here on technology and new technologies, and they can be used for good things, it can be used for evil things,
Yes.
right? And I think it's sometimes difficult to anticipate all those things, and you hope that the more the good ones than the bad ones that will survive. I mean, just take the location tracking ability of the cell phone, right? I mean, yes, it can, it can tell somebody that you're spending too much time in the grocery store, or, visiting somebody you shouldn't be visiting, or whatever. On the other hand, it could be used to track a child who's been kidnapped. It can be used for good purposes. I think to a priori say, okay, we're going to now make a cell phone that can't do that, can't do any of that, and all cell phones can be that way. I'm not sure that's the right solution. Okay?
To repeat the question, in case it was audible for the internet community, I use a term frequently borrowing from Shakespeare's Hamlet, that technology is neither good nor bad, only thinking makes it so. That's why I asked you about why you were calling cellular a surveillance technology, to separate how it was being used from what the technology is itself. Of course, this is why it's important, I think, for us to look at these issues from many factors and not just from technology. Because perhaps there's something inherent in a technology that is or could lend itself to problematic use. In which case, then you do want to have something to offset that problematic use, such as a law or a policy. Not everything is perfect. That won't take away the criminal's ability to misuse technology. It won't take away an autocratic and inappropriate government's abuse of the information that they have. But it will at least establish a value within the culture about how these technologies will be used and how government is going to operate, rules that the market has to use, and rules that users have to abide by as well. And so that, I agree with you entirely. Technology is neither good nor bad, only thinking makes it so. Steve?
I agree.
Fast comment and then we'll close.
I agree for the most part, although you just opened up a whole bundle of issues that we don't have time for. I would like to note that the privacy-aware approaches we've developed for cellular are options. The user has a choice whether to do the privacy-aware version or the standard version. And you mentioned tracking children, other things like that. Sorry if any of you are listening, I'm fully for it. I think it's a good thing, obviously up to a point, and the technology provides that in a nice way. It should be an option. It gets down to that one core concept that we should be in control of our data, not somebody else.
I'm going to leave it because this could go on forever. I don't want to just one thing to get done with it. But I like the idea of the government being able to track bad guys. And to maybe avert a terrorist plot or things of that sort by knowing where they are and what they're doing and how much of it they're doing and stuff like that. And if that can prevent another 9/11, I'm all for it. So I don't think the bad guys should be able to just turn it off. Use the good parts of it and shut off the parts that don't fit their evil intentions. So I mean, you could argue, both sides of that as well. So these are not simple problems.
No, but I think you would agree.
Here tonight, right?
You would agree there's a line, and that line has to be drawn somewhere. We don't want a pure surveillance state, and we don't want law enforcement to be hampered from doing anything. There's a line in the middle somewhere, and it should be discussed publicly.
Yes.
In other words, we should all have some input. The technologists, the law enforcement folks, lawyers, we should all have a conversation. It shouldn't be decided by them.
And I think on that point, that this really helps set up the next piece of this. We have 4 people who are in business, who are dealing with this on an everyday basis. They're going to come in and talk about the next step of this. So thank you to Tracy and Steve. I think this sets the stage perfectly. Let's give them a round of applause. We're going to take a quick 3-minute break. We'll just get the panelists up here. If anybody needs the bathroom real quick, but we're going to start literally at 7:15 43. So come back and get seated. So thank you very much.
It was right next to where the grapes and cheese were, toward the conference room, this way. No.
Let Tracy take it from there, and we're going to get into this kind of discussion. So welcome to the panel. Thank you.
All right, thank you very much. We'll give everyone a minute to sit down. Lisa, I would like to turn to you first, if you would be willing to give us just an overview of the legal landscape in the area of privacy.
Sure, I'd be very happy to. First, I think I'd like to start by making the distinction between privacy and security, because we tend to commingle those, conflate those concepts. We think of privacy as the appropriate use of information, and that's often defined by consumer expectation, individuals' expectations, and then codified later on into law. HIPAA is a great example of that, where there was a groundswell of concern over use of health data, and then the law came later, and the regulations came later. Security is the more objective factor, where privacy is subjective and based in culture. Security is more objective. It's the protection of information. It's maintaining the integrity of data, making sure that it's not altered in untoward ways. So just definitionally teasing those two concepts apart. Now, when we talk privacy, we are talking about personal information. So in most countries that have data protection laws overseas, there is a term, personal data, and there is a definition. In the United States, we labor under the difficulty of having many, many terms: personally identifiable information, personal information, non-public personal information, to describe something, but we've got lots and lots of definitions for that something. So we are in an interesting place where we have this body of information that we think about as personal data, but we don't have even a term to define it as such. And the FTC it has in some ways given up by using the term covered information now, essentially saying we're not even going to talk about that anymore. We're just going to call it something different. And then they've gone very, very far in what personal information is to include persistent identifiers, for example. So IP addresses, numbers embedded in a cookie, unique device identifiers, those are persistent identifiers that are considered personal information. And I would venture to guess that most of us in this room would not actually consider that to be personal data. But the FTC does, and that is the primary enforcement body for privacy in the United States. So, what is the legal landscape for privacy? I read recently, and so I have not personally verified this number, but it's an interesting number to throw out, that there are 92 data protection laws around the world. We have a fundamentally different corpus of law in the United States than many, many other countries. The dichotomy is this. We have in the United States what's deemed a sectoral regime for privacy, and overseas, and particularly in Europe, and many of us focus on Europe because that is, well, there are 27 member states, so you get to encompass a whole bunch of countries by thinking about Europe as a whole. Europe has an omnibus comprehensive regime, and that is the regime, because it's in fact an easier regime to mimic, that's the regime that many, many developing countries have now taken and made their own. So we think about privacy in the United States by industry sector. That's what sectoral means. We think about regulating financial information, health data, children's data, COPPA. You've heard Tracy refer to the Children's Online Privacy Protection Act. Children's data collected online for children under the age of 13. So we think about different industry sectors, different types of data. Overseas, in many countries that have data protection laws, there are these comprehensive regimes. In the United States, we also have federal laws, and we have literally hundreds of state laws. So we're in a bit of a mess here. We have, for example, in one teeny little area, we have 46 state data breach notification laws. When you have a data breach, meaning a compromise of certain sensitive personal information about individuals, you can bet that that data doesn't belong to residents of a single state. Typically, when there's a data breach, that data belongs to residents of every state. So now try reconciling those 46 laws plus a federal health breach notification law as well. It's virtually impossible. So we work it out, and we tend to go to the highest common denominator, or almost, if that becomes ridiculous. So why don't I stop there?
Okay, sounds great. Would anyone like to discuss how work in your corporations operates to implement these laws, and especially those corporations that have a global scope?
I guess that tees me up. So MasterCard is a global company. We're a payment service provider, but we're also a technology company in the payment space. And yes, you can use your MasterCard just about anywhere in the world, which means that we operate in over 210 countries and jurisdictions around the world. Not all of them are countries, so are legal jurisdictions, but it does mean that we have to take an approach to trying to harmonize all these laws that Lisa's talking about. I think it's important to note that outside of the United States, many of the laws, privacy laws, were written with a human rights type of point of view. They're for countries that do not have a Bill of Rights like our Bill of Rights, and so some of the basic protections that we as Americans take for granted are actually part of the privacy and data protection laws of different jurisdictions, and so that does complicate things a bit. In addition, the privacy laws are generally very culturally contextual, and so depending upon the history of that culture, how information has been used for good or for bad, that generally also sets a tone and an expectation in that society of how information will be used. And I guess, the first rule of thumb when you take on a privacy officer job is that you realize that you wind up being the voice of the consumer, and that consumer is a global consumer, and the aspects of that individual often change depending upon their nationality and their culture. And so many times you're trying to figure out what is a surprising use of data versus an expected use of data. And I think that's really where sometimes the context comes in. So when you use your MasterCard, I think, and the previous speakers were talking about this, I think that you expect when you stand at that register that we're using your information at that moment to actually approve your transaction, right? So it passes through from the merchant's location to the merchant's bank, from the merchant's bank through MasterCard's system, ultimately to your bank that has issued you your credit card. And from there, we get we pass back that message that you are approved, right? That this is a good transaction, that it is not a fraudulent transaction. But that means that certain things have been done with the data that may or may not surprise you if you think about it. And I think that's where it begins to get tricky, because how much are you thinking about the use of that information? How much of that is expected? So companies such as mine, we actually do surveys of all of the laws of all the different jurisdictions in which we operate. We then try to take an approach to begin to break it down to what we call harmonizing principles at least, so that we can begin to operate a global network, because our business is truly global, and you expect it to be. You want it to be the same experience no matter where you are in the world. But nevertheless, the jurisdictions in which we operate have different laws to differing degrees, and so we need to try to figure out how are we satisfying all those laws while generally operating our business in a very similar manner.
Just taking the chance to tease out what I think is one of the most philosophically interesting things that I think Joanne alluded to. Looking at the cultural context of some of these core principles of law, and this has come up a couple of times, I think, even in the preceding presentation, is really interesting and suggests some of the real challenges, I think, for the road ahead. We look in many European jurisdictions, and in many there is already an existing concept in law, which is the right to be forgotten, which intuitively seems right. Like, it seems like it's a pretty easy place to land, philosophically and emotionally. It's this idea that if information that you find embarrassing finds its way on the internet, you should have a legal right to have it taken down. Now, for my organization, obviously this creates some interesting challenges in that we organize and index information on the internet. So many times people misunderstand that and they think that we are the internet. So we receive these removals requests in many jurisdictions, and they're saying, my ex-boyfriend took compromising pictures of me, we broke up, it went badly, he's posted them, take them down. And there are national laws that allow people to make these kinds of requests. Now, that principle, even though it intuitively seems like something that most people could probably get behind, when you really think about it, when you think about where that road ends, you realize that it results in a radical erosion of the First Amendment. That this notion of freedom of expression can be dramatically eroded if you create a really robust right to be forgotten. It allows people to censor the information that's available not only about them, but indirectly about others. Similarly, there's just a really interesting anecdote. I have members of my team in the United States, in France, in the UK, and in Germany today. And we get into this debate, we get into this conversation frequently because there are conflicting social norms and we need to work through them even ourselves as a team. Because you do need a principles-based approach to compliance. Just doing sort of line-by-line compliance analysis is going to drive you insane. You're never going to get where you need to be. And when we have this discussion, and we have folks from some European jurisdictions that get very passionate about the importance of a right to be forgotten, the sentence that typically ends the conversation, or at least forces people to be circumspect and step back, is when my German colleague says, "I am extremely concerned that we not lose sight of our duty to remember." And then the conversation goes quiet as people stop and think about, this is a much more convoluted conversation than it necessarily seems at first blush.
That's terrific. Mark, I want to bring you into the conversation. I know that you have a company that is designs software for companies to use to work with their employees. Would you tell us just a little bit more about that and
Sure.
how that fits into this discussion?
So the company Tracy is referring to is a company called Thrive Metrics, and what it does, this is one of our portfolio companies, and it works with corporate communication, pretty much email mostly, to be able to measure the health of relation between a company and its customers. So what that means is the emails that are going between salespeople or customer support people and ultimately the end customer, more in a B2B as opposed to a retail scenario. We're looking at the frequency, the volume, the responsiveness, the topics, and the sentiment associated with this communication in order to see, are the relationship with a key customer, are they good, bad, are they going down, are they going to be changing relative? If we're expecting sales to increase by 10%, but the volume is decreasing and sentiment is decreasing, that might mean that you can predict that sales aren't going to increase for that customer by 10%. So,
What are the privacy implications
yeah,
of all
so,
of that?
it's funny, I like the way that Joanne put the, I'm the non-lawyer, I think the only non-lawyer on the group, so I'd be the technologist in the group. So I really like the term, the surprising use of data, because that for me is kind of just entrepreneurship. And I don't know if that's exactly how you intended it, but email is obviously intended for communication, and that's the first order purpose of the email. The second order purpose is that if you collect it and you can do analytics on top of it, you can get valuable information that can help management decisions, to grow a company. Now the privacy issues on that, at least in the United States, are cultural. So companies are allowed to do this. It's in most handbooks, and I'll defer to the experts on the panel on chapter and verse on that. But when the companies that we've worked with that have deployed this really have to make a decision on whether they tell their employees they're using this specific technology or not. And when we started the company, we weren't sure what people would do. We thought they would mostly not tell their employees. Just thought that might have been the easier way to go. But what we found is, in practice, is that usually the purpose of why you're using this technology, either to grow sales or to prevent customer attrition, are global enough to employees that they buy into it, and it gets the green light from, and they basically broadcast the use of this technology. And interestingly enough, one of the things that we track is not only the topics under discussion, like major initiatives, like diversity initiatives and sales initiatives, product quality, but also track the use of this product. And what ends up happening is there's a big blast, people learn about this, and it's promptly forgotten in 2 weeks. So, I think that's a phenomenon that is going to happen. I think those monthly reminders, I don't know if that's merited in this case, but which comes down to really a culture point, and that is, if it's, do people care about it? In our case, we found that people aren't that concerned about it, as long as they get the sense that it's being used for good. And to the extent that it can be shown where bad actors who could exploit it if you worked hard at it, and I think this is the case in the government too, and they do exploit it for some purpose that generally people would think is a bad purpose, then as soon as that comes to light, that will shake the foundations of their trust in the system. So far, the trend has been, they say this is useful for growing a company, and people are okay with it.
As employees.
Yeah, as employees, yeah.
Well, let me turn back to Lisa, because initially you made a distinction between privacy and security. And I'm wondering if you would be willing now to allow me to ask you to lay the landscape for cybersecurity, working this down to the question that I think Mark's description raises, is what kind of technical safeguards do you use to make sure that that information remains in the right hands, and does the good that you describe its potential to be? But Lisa, would you begin us first with a landscape of cybersecurity?
Sure. We have spent the last couple of years reading about how the situation, the cyber situation is degrading significantly. So what are the threats? I tend to put the threats into three buckets. First, traditional hackers, those people who are seeking financial gain, and they're after personal information to sell, to commit identity theft. They could be after R&D. And so sometimes nation states, and I'll put nation states into a different category in a minute, but sometimes a nation state will seek R&D so that they can be literally 10 years ahead of where they otherwise might be. Sometimes they're seeking intellectual property of some sort, or the hottest, newest product that hasn't yet been announced, or very super secret M&A plans. That's the kind of data that a hacker out for financial gain would be seeking. Second category is known as advanced persistent threats, and these are nation states who are seeking access to our systems in the United States, seeking to understand the blueprint of a water treatment plant, for example. Sitting in systems, they are persistent, advanced persistent threats, incredibly sophisticated, very patient, very persistent people who are doing this. And then the third category is the category of hacktivists, anonymous, lulsec. These are folks who are loosely grouped, pursuing some ideological purpose. They're really anarchists generally. So generally those three groups, and those three groups could be comprised of insiders as well. We could fit terrorists somewhere in those three categories as well. So how are we managing all of this? Because for the last year or 2 or 3 years, we have just been hit very, very hard in the United States. We had last fall a number of high-tech companies announcing that they had been hit, including Google and Facebook, Twitter. We had media companies. The New York Times went public. That was really, really quite an astounding thing. The stigma was gone because the New York Times went public with their hack, that they had been breached. The Times, the Post, and then this all comes on the heels of all of the distributed denial of service attacks, known as DDoS attacks, against the financial institutions, both in the spring and in the fall. And you've all probably read about Saudi Aramco, where the Iranian government, we think, destroyed 30,000 computers, just obliterated them in one fell swoop. So really, really just a huge number of events. So where did that all lead? In the fall, there was legislation both in the summer and fall that was defeated twice in this country to try to protect in some way against these attacks. And finally, the administration had enough, is really how I look at it, and issued in February, on February 12th, an executive order. The executive order, it's the executive order on cybersecurity. It has 2 very significant pieces to it that I'll mention. There are 5 or 6 concepts. Actually, I'm going to talk about 3. The first is that the government agencies are now required to share information with the private sector when there is specific threat information. Now, this started out as two-way information sharing, where the private sector was also intended to share information with the government, but that was highly controversial because there might be personal data bound up in that data shared with the government. And so the administration dropped that altogether, and we are left now in the executive order with the one-way information sharing. Second, and critically important, is that the executive order required NIST, which is a government agency within the Department of Commerce, to develop within 1 year, very, very aggressive timeline, a framework on cybersecurity for the private sector in this country. So we are going to have this framework document that is voluntary. It is not, compliance with it is not going to be mandatory. I heard a colleague use the term voluntold recently. I thought that was just a terrific term. So voluntary, sort of. Voluntary with ellipses after it. The third piece that I'll mention, because it's apropos of this panel, is that there's a privacy portion of the executive order, and it's really closer to the front than the back. And it's very, very amorphous. And what it says is that in developing this framework, you need to think, you NIST and the private sector that's contributing to the framework, we need to think about privacy and civil liberties protections as well in constructing this. So those are the really salient points. Moving on from the executive order, we in this country defeated legislation again in spring. CISPA, you might have read about CISPA. CISPA really had two very important pieces, and I'll tell you what they are because they're going to come up again in new legislation. One is two-way information sharing. Okay, so both from the government to the private sector and from the private sector to the government, but it includes immunity. So to the extent a company is sharing data with the government and that data may have some personal information in it or other proprietary information, the company would be immune from lawsuits. The company also would be given immunity for acting upon information it obtained from the government. So that's really where we are today. We're seeing lots and lots of bills being introduced in this space. I will tell you that our clients are being hit really hard in cyber attacks. Over the last few months, I've dealt with the Al-Qaeda Independent Cyber Army, the Tunisian Cyber Army, the Parastu, an Iranian hacker group that we think is tied to the government, and of course the Chinese People's Liberation Army in China. So, and this is just me, one lawyer. So we are being hit very hard in this country, and I expect that there's going to be a lot of we've been diverted a little bit because of the NSA issue. We've been diverted a lot, but I don't think we're going to forget about the cyber issue at all. And of course, it's very high on the president's radar screen, and it was part of the discussions with the Chinese leader, and it is also going to be discussed at the G8 summit.
Thank you. That was excellent, Lisa. Keith, do you want to
Sure.
toss a few words?
Yeah, I mean, I think Lisa did a great job of setting up the urgency
Yeah.
of the situation that we're facing now around security. Obviously, for a company like Google, privacy and security are really existential concerns. We absolutely have to have the trust of our users, or they'll discontinue use of our services. One thing that I do think it's important for folks to really take a minute to understand, though, is when we talk about privacy, and all of the fear and uncertainty and doubt, we call it FUD, that kind of builds up around this conversation about privacy. People get so emotive and so nervous about it. And you hear then legislators, policymakers, regulators using a lot of that angst that people feel about the uncertainty about the web and where things are going to justify heavy-handed regulation, extraordinarily aggressive enforcement, sometimes impeding competition or impairing our ability to innovate. Sometimes it's worthwhile to step back and wonder what's going on behind all of that FUD, like what's it really all about? And I think some of the best data we have here actually comes from our most aggressive domestic privacy regulator, the Federal Trade Commission. Every year, the FTC publishes statistics about what consumers are telling them they are most concerned about. And every year, I think now we're up to 15 of these annual reports. The top 2 concerns, by extraordinarily wide margin by consumers, are financial fraud and identity theft. Now, the question that I would leave for practitioners and for regulators would be, it would be interesting to look at how many lines of type in the Journal or in the Times are devoted to the prevention of financial fraud and identity theft, as opposed to things like using anonymous cookies to deliver interest-based advertising. That's not really what's keeping consumers awake at night. It is these threats. It is things that are going to cause people real financial and economic harm. And there are lots of things that companies like Google, like MasterCard, can do cooperatively and collaboratively with the government to really move the needle to improve the experience for consumers online and to better protect them.
Right, Joanne?
Sure. I think that we live in very interesting times. I think that there's an absolute tension to kind of build on what Keith is speaking about between privacy and security. And I think that as a society and as a global society, I think that we are just beginning that conversation on how do we balance the use of information to keep us all safe from harm, but at the same time protect the individual from maybe incorrect conclusions about that person. But we struggle with this at MasterCard, and really, when you think about it, much of our business is protecting your financial information. And in order to do so, we do a fair amount of monitoring of fraud on our systems, on attacks on our system, because the data that we transmit is incredibly valuable for identity theft in particular, right? As well as hacktivists enjoy our brand name as well, and we've had some fun with that. But at the same time, how do we use our information, right, to make sure that your transaction is actually being approved by you, that it's you using your card, that it's not somebody else who has lost your card? And then how do we work with the government to actually find those individuals and ultimately prosecute those individuals? And that requires a sharing of information in order to take those individuals out of circulation. And let me be clear, those individuals are not one, everybody has a point of view of an individual off in a garage someplace, but these are very organized businesses. The theft of information in parts of the world is a big business. And they use the same type of tools that legitimate companies use in order to steal information. And so how do you balance that with the desire to actually provide the service that my company is actually entrusted by all of you to provide, right? Safe, secure payments around the world is one of the things that we want to make sure happens. And at the same time, do you recognize in order to provide that service, we have to balance your privacy with the ability to actually keep that information safe. So this is going to be, I think, the ethical conversation. The NSA is going to help push this, the cyber attacks, and as those keep happening and they become more public and understood, I think, are going to be the counterbalance to this conversation. So I think we're going to see a whole lot more about this. But it does place a privacy officer, and I am a chief information security officer, and the two of us have to really work hand in hand in order to resolve some of these issues for the organization.
Terrific. Mark, do you want to comment on that?
When you look at it from at a corporate perspective, you look at corporate communication, is I think a microcosm of this issue, and why, and I think to Keith's point that, why do people, what do people really care about? They really care about, they care about the security of their job, they care about the health of the company that they're working for so that they have a secure job. And then there's second order ones, which is, I don't want my employer to find out that I am sick, pregnant, gay, something. And those, I think those are legitimate concerns, but I think that there's a pecking order in most people's mind of the things that they're concerned about. And at the corporate level, before they decide to deploy something that is going to monitor for the health of the overall company, there's a dialogue that goes on pretty much, let's say, in management, whenever they're considering a system, at least like ours, in our experience, and that is it's usually somewhere in between human resources and operations and sales. And HR is caring about people wanting to still work there and this be a good place to work, and they're not going to, they don't want to spoil the trust that the company has with its employees. Where sales is paid to keep the company going and growing, and there's a dialogue, and that dialogue will actually get the technical points of okay, HR might say, okay, sales, you can we can see how this is legitimate use, but we want to make sure that you're not collecting things in groups that are smaller than 12. So we're looking at these usually big companies that are deploying this. So we want to make sure that there's some level of anonymity so that, in just the same way that surveys are anonymous, sometimes by third party or sometimes you just don't know your name. You just say what department you're in. So I'm really interested in, from a cultural point of view, what are the perceived checks and balances that are in place? And what are the actual checks and balances of people who are looking at both sides of the problem to make the right trade-off decision, whether it's a corporate communication or bigger for government.
Sounds like as a technologist and businessman, you're starting to incorporate privacy-aware design just by virtue of the fact that it's part of what one must do now in order to be a saleable product and company.
But it really is. I mean, responsible organizations that have privacy officers and privacy organizations, we call it, privacy awareness design, but we call it privacy by design, which is a term that a Canadian privacy commissioner actually coined. So we'll give Ann Kabukian a shout out for that. But it's actually really is exactly what it sounds like, that the privacy considerations are part of the product design. And so at MasterCard, one of the things we do is my team and I, for any information-based product or service, and that goes for fraud products all the way through to priceless cities campaigns that some of you may have joined in, and I hope you do, for different kinds of priceless experiences. All of those products and services are designed with my team at the table. So we are considering what are the implications of information use.
Mm-hmm.
What are the positive benefits? How do we make sure that you are actually understand the use of your information in order to provide you with a service or experience? So that is exactly what privacy by design means. Mm-hmm. So I think a lot of organizations are moving toward that, and it means the privacy officers need to understand not just the law but the technology. I think I was one of the first lawyers at MasterCard who demanded a whiteboard in my office because I needed to draw data flows in order to understand exactly how information was going to be collected and used and transformed into a product or service, and to make sure that it was actually protecting an individual's privacy as part of that design process.
Mm-hmm. Yes, ma'am.
Yes, I have a question because I just cannot understand all this, what you are saying. First of all, you are saying that you are trying to get my privacy protected, which is not true. MasterCard or any other American Express card or whatever card is, makes me talk with Japan, with Philippines, with India, just to get cheap labor, to get all my personal information, just to get my information when I want to talk to them. Verizon is leaking my information to the government. When I get all this information to somebody in Philippines, which you don't know how they are going to use my information, you're saying you're doing that on my own benefit? I don't believe that. That's one. Second, I think we are here parents of Cornell, and I would like somebody to talk about how to protect our children from Facebook and all these things when they talk about what they had for breakfast, who they slept yesterday with, and what is their mental health problems. I think that's what we should be talking about here, because everything else is completely lies.
Okay, I first need to correct one misimpression. So the company that you do business with, if you call the customer service number in the back of your MasterCard, that is actually your bank. It is not MasterCard. In China, in India, that is your.
I asked them where they are.
I appreciate that, ma'am. I'm just saying it is not my company that you're dealing with.
So why
you're dealing with your
Americans are
bank.
not getting jobs to American people rather than giving it in the rest of the world?
I can't speak for my banks. I'm just saying it is the bank that issued you your card that you're dealing with. You're not dealing with MasterCard.
Usually the people I talk to on the weekend, which is when I can talk to because I'm working the rest of the week, they are in Philippines, in China, or somewhere else. And everybody else in this room has the same experience.
So let me turn now. We were going to mention things about the cloud and mobile computing and so on and so forth. Does anyone want to say a few words about that before we get to the questions related to the content?
Sure, I'm happy to do that. We are, as a society, turning toward the cloud. It's an incredibly effective and efficient business model. There are privacy and data security considerations that we've been now thinking about for a number of years. So I'll give you a tidbit on that. First, which jurisdictions' laws apply? Is it the jurisdiction in which the server sits, where the data sits at any given moment? And remember, the data can move around the globe, and does move around the globe because that is the business model. Is it the jurisdiction of the data subject? Is it the jurisdiction where the corporate headquarters is of the cloud host? So we have a basic question of which law applies. Now, we can usually figure that out as lawyers, but this is actually pretty naughty, and we don't really know the answer to that. We'll figure that out over the next few years, I would imagine, but we are struggling as a legal community over that question. The second big issue is security, right? You have this treasure trove of data. Now, it is the case, it's fact, I think, that the big cloud hosts, the cloud providers, are enormously secure. They have really tremendously important and successful security mechanisms around that data, probably much better security than most companies can provide if they did not use the cloud for their data. Other issues. There are, in some countries, restrictions on the transfer of personal data from jurisdiction to jurisdiction. So if the data, and particularly in Europe and other countries that have European-style regimes, if the data is moving from Europe to Singapore, to Philippines, to the United States, that data is moving all over the place, and we need legal mechanisms. There should be legal mechanisms in place to be able to legally move that data from place to place. And I'll mention the last item on the sort of the checklist of why people are concerned about the cloud, and that is loosely called the Patriot Act. So this issue is made all the more important, of course, today, but we've been talking about it for a couple of years in the cloud context. There is the misimpression that the United States has more stringent laws or laws that allow us to reach into the cloud and pull data about individuals in a way that is disproportionate to the laws in other countries. That's really not true. Many jurisdictions have these laws in place, allowing them to reach into the cloud to pull data if they want to protect security. But we have this nifty little law with an acronym that's very attractive to the press, called the Patriot Act, that other countries have picked up on. And really what we're seeing is job protectionism, because what some folks in Europe, for example, are saying, cloud hosts in Europe are saying, use us because the US government can't reach into our cloud. Well, no, but the Dutch government can, and the French government can, and the Spanish government can. So those are, in a quick nutshell, you guys may think of others, but 4 very significant issues when considering cloud.
Does anyone have, from the panel, a final remark? I want to note that we are at 8:21, and in order to give folks questions based on the content, if you've got a fast thing, go for it. Otherwise, we're going to open it up there. Okay, excellent again, Lisa. Thank you.
And one quick thing with the questions. I'm going to ask if everybody can ask one question. Please do not debate with the panelists. We have a lot of questions in the audience. And please be respectful of the other people in the room and your fellow panelists up here in terms of what is sort of getting thrown at them. So with that, Tracy, please open up the question.
Where did I see the first one? Yes, sir.
So as you look at industries such as healthcare, the issue isn't about the importance of security or the importance of privacy. The question comes down to efficiency, meaning how much access do you give to which people in terms of getting to the information, and how efficient is that going to be in terms of expanding access, since the breaches are more often not from the major groups that you think of, but individuals like a physician who actually checks up on their friend who's in the hospital when they really shouldn't have access to that.
So, HIPAA is arguably the single most stringent privacy law in this country. It's comprised of 2 pieces, the privacy rule and the security rule. And I will tell you that the security rule is ancient at this point. It came out in the early 2000s. It's like the dark ages. But it's still a very good rule of thumb because it's broken down into administrative, technical, and physical safeguards. And we have more detail in this health privacy law than we have in other privacy laws. One of the key aspects of the security rule is access controls and availability. So, and that, those are slightly dueling concepts because we need to make sure that the right people, that the data is available at the time the physician or the hospital needs the data, but we also have to make sure that there are appropriate access controls so that the doctor can't check on his or her friend, but can check on his or her patients.
There was another question here, and then I was going to start going around. Yes, sir.
Just a comment.
Oh.
I think all we've been discussing has a tremendous implication from a corporate governance point of view. If you're a public company, a private company, a not-for-profit company, you better get this subject in front of the board, and you better have a plan and a response plan in place. This is vitally important. And you also better look and see what insurance you have, if any.
Excellent comment. Yes, sir.
I guess my question is less about disclosure and more about your obligation as a company once you have this information. So if you're Google and you're MasterCard, and if you're Google and you have a G-chat around making a pressure cooker bomb, and you have a search around the Boston Marathon, and you've got communication between a foreign national in the United States, or your MasterCard and you've got an easy pass statement of the Lincoln Tunnel, you've got buying propane and renting a U-Haul truck. At what point, you as a company, are you responsible for disclosing that information? And could I, if I was a victim of a terrorist attack, go back to you and say, you should have known that this was coming and you didn't disclose that information?
There's a lot to unpack there. I think one thing to speak to just as a baseline is the responsibility to report alarming or anomalous behavior that you're seeing reported in communications presumes that you're actively monitoring those communications, right? I, for one, don't think, I don't want to speak for Google kind of monolithically on this, but we don't want to build a surveillance apparatus for any government. So if you think about something like the contents of your Gmail, for someone to get access to the contents of your Gmail, we need to be provided with compelling, binding legal process that we have to comply with as a matter of law. We have no interest in reading the contents of people's Gmail and making moral determinations as to whether something should or shouldn't be escalated to somebody else for review. And in point of fact, that would be antithetical to the entire philosophy, the privacy philosophy of the company.
At a risk of debating, what if you then served that person an ad for propane based off of what you're reading in their email? And now aren't you culpable for contributing to the potential terrorism?
So, no, but a couple of things there. So the way contextual advertising works is in many ways similar to the way that virus scanning works, right? So you have an algorithm that pours across the content of a communication, looks for heuristic patterns, and then uses it to deliver what is reasonably believed to be a relevant interest-based ad, right? Interest-based, relevant, using on the context of the communication. If someone has the word propane in an email, that does not suggest that they are a terrorist or a jihadist, right? It suggests probably that they want to grill. So there's a very real false positive problem there. And again, I do think that there is a proper role for governments to figure out to what extent, bound by social norms and bound by appropriate values, they should figure out, they should build surveillance capabilities that are constrained by law and by constitutional values to protect our citizens. That's not what Google's job is. We provide products and services to our users, and we do it in a way that complies with all the applicable laws.
Yeah, from a MasterCard perspective, you presume that we are actively monitoring all of your purchases and linking them all together, and that we know the content of what's in your shopping basket. So what I would actually see after the data has cleared our system and at rest would be a series of transactions that might be as innocuous as you live in Manhattan, you used your Easy Pass to go to New Jersey, you bought gas on your way to Home Depot to pick up a can of propane, I wouldn't know it's a can of propane, to transact at Home Depot to then return to Manhattan would be the most I could glean from our data. So we don't have what we call your shopping basket or SKU level information. That's a mistaken notion that we actually collect that information. We don't. So what we would have the same problem of trying to parse out the context of what is a good transaction versus a bad transaction, and we also don't do it in real time that way. So we would do it within we might have the information within 3 days, but that's just not how our system is designed.
All right, this side of the room, I'm going to work it back. Yes, sir.
Yes, I'm curious from the perspective of a publisher, people who have sites. There are two schools anyhow, in terms of privacy, that being the opt-in or opt-out. So are you in the United States where you have to take the affirmative action versus are you in Europe where you'll have to agree to it? And I'm just wondering, to the extent we're discussing reconciliation of these things, I know I'm involved with a company where we can geolocate. And so that's one way of kind of managing it, but I think that at a certain point, it's not going to be that easy.
Please.
I mean, when you use your MasterCard to a certain extent, you're opting into using our service. So there is an opt-in every time you swipe or use your card. For all other programs, we've designed them as opt-in when you are interacting with my company, mostly because we don't have it, all we get when you transact with us is actually the card account number, the date, time, and place of the transaction, and the dollar amount. So we actually have no way of reaching out to you to send you an email to assume that we know who the identity of the individual is. So all of our programs are actually opt-in programs because you have to affirmatively decide that something that you've heard about, whether it's from your bank or you saw it on the side of a bus, that you want to engage with my company. So our programs are actually opt-in.
So a couple of thoughts on that as
Yes.
well. First, I'd say the opt-in, opt-out binary distinction is a little misleading and a little antiquated. If you look at the way technology works, you look at the way the internet is evolving and just the way interfaces are evolving and user experiences are being designed. You can look across our portfolio of businesses at the various things that we do. We devote a tremendous amount of resources to trying to understand this question. There was a point made earlier on some of the opening remarks about what does consent really mean? What level of information and understanding does the user really need to have to give informed consent? We work really hard at trying to solve that problem. One example would be with Google+. When we rolled out the social network, as opposed to having just a really verbose, legalistic list of terms that you click through at the front end, where you agreed to a whole lot of things that you may not have had the attention span to fully review and digest. We really tried to implement contextual, just-in-time kind of notifications. So if, for example, you put a post on Google Plus and you want to share it, or if someone shares a post with you, but they share it only with you, say it's a photograph of their child and you're a family member, and they don't want to share that publicly, they share it with you, you do, as a user of Plus, have the ability to reshare that content. But if you try to reshare it more broadly, a reminder can pop up that says, this person shared this with you individually, you're about to share it more broadly, are you sure this is what you want to do? And you can say, oh no, no thanks, or okay, I've got it. Those are the kinds of things we want to figure out. How do you put the right information in front of people so that they're making informed decisions? And there are huge technical challenges to this. As we all migrate to smaller and smaller interfaces, getting the right amount of information so that people can make informed decisions is a real technical challenge.
Gentleman in the back here. Yes, sir, white shirt.
Yes, I'm wondering about privacy policy. I mean, it must be a challenge. I've been in IT security technology for 15 years, and I don't read all the privacy policies in my stuff. It's fine, print, agree, check, okay, fine. They could do anything with my data. So I'm wondering, how sophisticated, am I typical where, people just check? I mean, I have no idea what MasterCard's doing. I'm sure it's honorable, but I don't know.
I think that's what Keith was trying to get at, that actually privacy policies are one place to try to disclose all of the uses of information, but the challenge is that in order to meet all the legal requirements, right, we tend to be verbose as lawyers, so you're right, they're not necessarily the easiest documents or ones that people want to read. I think it's more important, though, that when individuals interact with organizations, that they have an understanding of what the core service is, and that they get that real-time interaction. And I think most companies are trying to move to a conversation-based approach or a preference center so that you can begin to manage what that relationship is going to be and what type of information you want to exchange for what type of offers. But it's tricky because you need to build an interface that is flexible enough to kind of honor all of the different choices, and I would argue that many of you would have a different choice, right? And so how do we then organize all of that information, then honor that, and then also have the ability for you to change your mind? But I do think that is exactly the conversation we're trying to move to, is this kind of online conversation to honor your preferences and to begin to give you real-time notice, as we call it, of what the service is you're about to enter into.
I think one of the fundamental problems is that a privacy policy, while it's supposed to be a communications tool to inform the user of a company's information practices, it's really a legal document. Having written several hundred of them, I can tell you that they're completely incomprehensible. They require a JD to read. And the reason for that is that we don't want to put any company who we represent at risk of violating Section 5 of the FTC Act that prohibits unfair or deceptive trade practices. And if there is something in your privacy policy that is not true, not accurate, deceptive, you are at risk for a Section 5 violation.
Boy, quick question, and then I'd love to have another woman ask a question if John will let us.
Yeah, we absolutely
Okay.
are good.
Very good.
Keith, you said that Gmail was private unless the government served a subpoena or something asking for data. How many times a day do you get those from the government?
So I appreciate the question. One of the things that we are especially proud of at Google is that we were leading the industry in creating something called the Transparency Report. You can Google it, and what it will do is it provides information about the types of law enforcement requests we receive by jurisdiction around the world. You can actually see a map and you can zero in country by country. There's some really surprising information there. A lot of it seems counterintuitive. We also give you information about what percentage of them we complied with, which gives you a sense of how hard we're pushing back and in what jurisdictions we successfully push back, and where there is a strong legal process where we simply have to comply because the law requires us to provide certain information.
Brilliant, thank you.
Yes, ma'am. You will be our last questioner.
Okay, my question, I guess, sort of relates to that, and it also relates to the right to be forgotten that was being discussed in the beginning of the panel. So by way of why I'm asking this, I wonder, as a first-year associate at a law firm, I have been tasked with a lot of document review. And we obviously find most of our most interesting things in emails. And so I was wondering, relating to the right to be forgotten, and sort of, I guess, when you are served with some type of document production request from the government or really from anyone, what happens with the things that are in the trash, right? Because I know, for example, that there were issues with, complying with our hold request to not throw away documents electronically. And we were able to have, a forensic company pull those documents so we could review. And then I was thinking about what was being discussed in the initial part of the panel, like reasonable expectation of privacy, which is, okay, you're throwing something in the trash because you don't care about it. But conversely, I have a colleague who says, I throw everything in the trash and I don't want anybody to read. So I know that when you have a physical trash, you put it on the street, you're probably, you have no privacy in what you throw out there. But I'm kind of just wondering what happens in all of those contexts with, email users who are tossing things in the trash and you don't really know why, because why would anyone explain that? And what happens when you get that kind of request, and if your client has that kind of issue, what do you do?
Go for it, and in the course of answering, if you want to make any kind of a final remarks, go ahead and leave those in.
I do want to take one online question from
okay.
somebody. We have a lot of people online.
I'm delighted to go all night.
So, panel, you guys can.
I'd punt this one to the actual lawyer.
Okay, so I'm confused about what the actual question is.
I was just wondering in general, I guess, your thoughts about, if we're talking the right to be forgotten versus, turning it over to the government, or what the relationship is between the companies and the government. Like, what happens if, isn't the first place you think to look for something incriminating be the trash? If someone was thinking, I want to get rid of something. So I was just curious.
Well, so there is a concept in the United States, as you know well, doing all the document work, that the moment there is anticipation of litigation, you are not permitted. You are not allowed to dispose of or alter records that might be relevant to that litigation. Similarly, if there's an audit, if there's a government audit, you're not allowed to alter information, and alteration is disposition. If you dispose of that information, you're altering it. There are dire consequences in litigation if you don't abide by the legal hold or the litigation hold. You could be hit with an adverse inference ruling, which means that any evidence you might have to rebut an inference made against you, you would be assumed to not have appropriate evidence, and therefore you essentially lose the case. So it's very problematic.
So I know, I understand. I appreciate that. I meant more like what happens, like, I guess, if someone who's not, you know, in a litigation, right? Like the government's reaching out and saying, you know, turn over, I don't know how these things look, turn over this information.
So
you know,
this
is that
is-
something you look at?
Well, I mean, what many companies do from an information lifecycle management, you have what we call record retention standards and policies, and that's really what governs how long you keep records. And so the goal is to, you know, this is absent a litigation hold that Lisa was talking about, that certain types of documents and records get automatically deleted and destroyed over time because it is not really the right to be forgotten, which is slightly different and broader, but it's just good data management. After a while, data gets old. It takes money to keep it all on servers. It runs out of its useful life. So, you know, usually most companies use their records management program to delete information absent a litigation hold. And when there is a litigation hold, then those individuals who are subject to that, there are technological means to make sure that their data isn't destroyed, as well as that they're put on notice that they can, you know, that they need to not do anything to alter the records. So I think that's mostly how companies handle it. It's not that, I don't think people generally in business, I mean, I guess as my closing remark, I would say this, I don't think businesses are trying to do harm. I think most businesses are trying to provide a product or a service. And what we've discovered in this information age is that information provides insights. And so insights then allow us to refine our products or services and actually try to improve them for everybody. That being said, you need some kind of balance to make sure that it's being done in an ethical and mindful way. And hopefully that's most companies who have privacy officers and privacy programs and information security programs, that's what we're trying to do. So I think it is a balancing, but I think as the previous panel said, the law's evolving in this area and it's behind, the technology is evolving, our business colleagues are innovating, so it's a conversation that's going to continue. I can't sit here tonight and say we have it all figured out, but I'm really glad to be part of the conversation, and I think there's going to be lots more ahead on all of these topics.
Terrific.
So we
Do
have
a
about,
question
we
from
have
the-
200 people, over 200 people from around the country. We're going to take one question from these folks who are coming in. Ashley?
They want a lot more than one question, but yes, we're going to do one. And there's a bit of clarification along the way. This has been a thread. So the question is, the recent NSA data leak points out the issue with clearance of the tech individuals who have access to data and how to build safeguards. Do you have any recommendations? Now, here's the clarification. Safeguards around IT personnel who can access data from within the organizations, and this alumnus works at IBM. So they can create levels of access and sign-offs, for instance, to access certain data and perform queries on that data. You would need 2 or more IDs to log on, so any kind of recommendations for this alum?
Disable the USB drive.
Well, we do. So, yeah, I think that this is where the privacy officer and the information security officer work together on access to an organization's information. So a lot of those suggestions are state-of-the-art type of recommendations. So you set access based upon the role of the individual. You also try, in our organization, we redact a lot of information. There's not necessarily a need to see the full account number for all of the activities that we have to undertake. So you can truncate it, you can redact it, you can create what we call de-identified data by creating a different user ID that's not linkable to the underlying card data. We have processes and procedures that, as we design systems and processes, they have to be vetted by me as well as the information security officer, as well as levels of access. And then in addition, for any what we call ad hoc uses of data, those crazy ideas that people just go to the data warehouse and say, I want that data, all of those requests have to be run through my office for approval. So you try to have levels, and then you really have to do training and make people aware that the underlying data means something to an individual, and so stop just thinking of it as zeros and ones, but think of it as, you know, belonging to your grandmother is kind of what we try to say.
You know, I think this all boils down to what Joanne articulated a little bit earlier, and that is we need protocols, we need balance in how we're using data, so we have to think about what those protocols are, and what is proportional to the events that we're trying to prevent, number one. Number two, we need transparency in the processes So we need to talk about and make people understand, help people to understand what those protocols are. And I think what that leads to, if this were an equation, it would be sort of protocols in balance plus transparency equals trust. And then ultimately, if you have that equation, then there is a sufficient trust so that people are not, we users, individuals are not reluctant to provide data because we know that there are safeguards in place to protect the privacy of our information and to protect the security of our information.
Go ahead, Mark.
There's one thing that I'm reminded of. It's not a government, but it's more of a corporate. In banking, in financial advisory services, there's an idea that there's an obligation for oversight. So if you're the manager and you have financial advisors who are advising people underneath, who are customers, end customers, on what stocks to buy and what to do with their investing, there is this obligation for oversight. And so the tricky thing, and I think this is where it comes down to two major forces, and that is there has to be a dialogue, and there has to be checks and balances built into culture, government, and corporations. But there also has to be an understanding, more and more of an understanding of the technical aspects of this. So for instance, if you're managing, imagine you're managing 12 financial advisors, and you have an obligation of oversight, but that means you have to actually look at the emails from time to time. And there's different banks have different policies how many emails you have to look at. But when you're looking at at these emails, looking for something specifically which is inappropriate advice, or pushing of two sides of a trade at the same time, and you find something that you stumble on, like you were mentioning before, that you didn't expect, but it's against the corporate, culture / goals / ethics. What do you do? And at a certain point, let's say now the scenario is you have a financial advisor who has been sexually harassing colleagues, and you see this in the course of trying to see if he's pushing the wrong products with the wrong level of vigor. And now you have an obligation. So you had this system in place which was there to make sure that you weren't that the financial advisor was acting as a fiduciary responsibility for the customer. Then you found something else, and then the person who was harassed, now is the company liable, for not acting on that if they could have seen it? Maybe they didn't even happen to sample those emails. So this is such a thorny issue where you've got competing interests on both sides, and with all respect, there's just no one simple answer to this. To one of the questioners before, but I do think that it's surprising to me the amount of technical knowledge and know-how the people who are in charge need to have about the products, and it's just there's no getting away from that.
Mm-hmm. Keith, do you want to make a last remark?
No, I think it's okay.
All right, very good. Well, I certainly want to thank our panelists for a very enlightening and enjoyable conversation on such a complex topic. And I'm going to hand the microphone back to John to conclude, but also to thank Sarah Dupree and John for the excellent work they've done to pull this together. It's showing that higher education can be very helpful in framing the conversations about what's important in our culture today. John?
Well, listen, everybody, thank you so much for your time. Let's give the panel a warm round of applause. As predicted, we ran a little over. We could have been here all night long. I know you guys have given some time tonight. I hope you found this interesting. Thanks to all those folks online, the 200 plus people around the country. We appreciate that you're joining in. And really thank you all for just being here, and thank you to the panel once more. So help yourself. I think the wine is still out, possibly. I'm not sure. But thank you for coming, and thank you to the panel.
Great, thank you.